Foss Maritime for over 30 years. I found that their motto, always safe, always ready, is not always the case. Okay, the reason I know that, because they didn't take care of me when I got hurt. I strongly recommend for all my fellow seamen, when you get hurt, this is what you should do. Follow up with the company, find out how serious they are about getting you healthy and getting back to work. And if they do drop the ball, shuttle you off, or stall you, look for legal counsel. I worked for Foss Maritime for over 30 years, and this is what I think about them today. They are really good with you if you're not hurt, if you don't have an injury. But when you get thrown into the system, they seem to forget about you.
By any measure, the maritime industry is without a doubt one of the most dangerous industries to work in. Workers in this industry are exposed to virtually every kind of safety risk there is. Ships on the open ocean are obviously subject to the elements, and those who support the industry from onshore have their own safety issues to be concerned with too. Virtually any safety issue you can think of is at play in the maritime industry. But here's some of the most common: defective ship products, adequate safety training, toxic chemicals, explosions, sinking vessels. So, how are safety issues regulated? The maritime industry is, of course, subject to the rules and regulations of the Occupational Safety and Hazard Association, commonly known as OSHA. But other laws further regulate safety in this industry. The Jones Act exists to protect workers who earn their livelihood on seagoing vessels. There is also the Longshore and Harbor Workers' Compensation Act. This law is in place to protect the rights of maritime workers who support the industry from onshore. But because both of these laws are in place, maritime workers are entitled to seek compensation when they are injured in accidents during the course of their duties. For seamen, sailors, and ship workers who spend more than 51% of their time on a vessel in navigable waters, the Jones Act is legislation that made maritime law a federal obligation. The Jones Act deals with injuries and illnesses that occur out on the water. It means that if you were injured or became ill while on the water, you're entitled to recovery, no matter who's at fault. You do not have to prove guilt or unseaworthiness. Under the Jones Act, a worker who was injured or became ill during the service of an ongoing vessel is entitled to the rights granted under maritime law, including maintenance, cure, and unearned wages. Benefits under the Jones Act and maritime law allow for basic remedies, but additional benefits may be awarded if it can be proven that your employer or ship owner was negligent or that another crew member was at fault. In this insider-exclusive Investigative Network TV special, our news team goes on location in maritime worker rights Richard Amavisca's story to examine how Kirk Micklow and Edward Bull III, partners at Brodsky, Micklow, Bull, and Weiss LLP, successfully won a major verdict for Richard Amavisca. Kurt and Ed explained that protection workers are entitled to working on these dangerous rigs under maritime law. Maritime law recognizes those who work on the water, such as seamen, dredge workers, captains, and crew members, frequently work in dangerous conditions. Depending on how a seaman was injured, general maritime law, the Jones Act, and unseaworthiness dictate his or her entitlement to compensation. Each of these particular maritime claims has unique and specific requirements in order to obtain compensation from ship owners and operators. Richard Amavisca is a longtime member of the Inland Boatsmen Union. He spent his entire 30-year career working for Foss Maritime and its predecessor as a deckhand on their fleet of tugs and barges. Throughout his service, Rick was universally regarded as a loyal and very hard-working employee. He consistently received the highest exemplary performance evaluations from the company and was well-liked by everyone at Foss. In August of 2012, Rick was working aboard the Foss tractor tug Lynn Marie. The vessel's bow winch was having problems, free spooling, and the captain had to fix it immediately because the vessel had a job scheduled. As a part of the repair, The captain and engineer decided to use steel bars and pipes as pry bars to repair this problem. While Rick was pushing and pulling a bar, he hurt his lower back and aggravated his knee. Rick had to leave the job due to his injuries on August 20th, 2012. As soon as he left and made a claim, the company turned on him, claiming the accident never happened, accusing Rick of being a liar and simply wanting an early retirement. At trial, Kurt and Ed won by proving that the accident happened exactly the way Rick said it did, that the accident was the cause of his disability, that Foss was negligent under the Jones Act, and that the brute force pry bar task was an unseaworthy method of repairing the bow winch. The jury decided in Rick's favor under the Jones Act because of Foss Marine's negligent and unseaworthiness. Foss Marine had a duty to protect adequate safety equipment for the vessel. The jury awarded Rick damages totaling several times the defendant's final pretrial offer. The case ultimately settled for a confidential amount following trial. In the maritime industry, there is a fairly common story: a loyal employee who becomes the enemy as soon as he or she retains an attorney to help them with their Jones Act cases. Rick's case demonstrates why the maritime laws protective of seamen are still needed, and why Congress decided to allow seamen to pursue their rights in court as opposed to some workers' compensation system. Kurt and Ed have earned the highest respect from citizens and lawyers alike as some of the best maritime trial lawyers in California and across the nation. They've built a substantial reputation nationwide by consistently winning cases other law firms have turned down. And their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from San Francisco, California. It is my great pleasure to introduce Kurt Micklow and Ed Bold to the show. Welcome to the show, guys.
Thank you for having us.
Tell our audience a little bit about your firm. What type of law do you practice? Ed?
Well, we practice exclusively maritime law. We've been doing this for, personally, I've been doing it for over 25 years. That's what we do. And we took our training and experience representing Lloyd's of London, other major defense industry companies, and took that about 15 years ago to doing exclusively a plaintiff's practice. So we represent individuals and maritime businesses and in pursuing their rights against insurance companies or against employers in the maritime industry.
Yeah, I've met a lot of lawyers who initially started out their career working for defense firms. In other words, they were representing the major corporations. So a lot of them eventually switch over and help the little guy. Why did you guys do that?
Well, we did it because there was kind of a schism that developed in our firm. There were several partners who wanted to continue representing ship owners and representing Lloyd's and the P&I clubs. And a group of us, on the other hand, started doing some plaintiffs' work, and we represented a quadriplegia victim one time very early in our careers when we were still defense lawyers. And once we started representing employees, we realized that it was a lot more satisfying, and that we were very effective doing it because of our training and background on the defense side.
Mm-hmm. Well, thank God for that. And I can tell you a lot of workers probably appreciate that. Today, we're here talking about a case. Your client, Richard Amavisca?
Amavisca, yes.
Amavisca. And tell our audience a little bit about Richard.
Well, Rick is a kind of a classic maritime worker. The industry draws in great people. You know, he's a family man. He worked for Foss Maritime for over 30 years.
Yeah, one company.
One company. A lot of maritime workers, they may be hired out of a union hall, so they may have that same dedication. They may work for dozens of companies. Rick is somewhat unusual working for one company, but he's very representative of hardworking individual and a guy who really was entirely dedicated to the company. And you know, it becomes, because these workers spend so much time at sea, they see these companies more as family. You know, we've had to tell juries more than once that
You know, like Rick thought this was his family, and when your family turns against you, that's particularly hard. So he's an individual who, you know, it was a family man, hardworking, and in fact, at the time of this accident, he had been working, had remarried his wife. They had been separated for a while, and she had been diagnosed with cancer. And you know, like his character came out there going and taking care of his wife, who tragically he ultimately lost. But just a great guy, hard worker, and the kind of person we're really proud to represent.
What kind of job did he do?
He was a deckhand for Foss Maritime, a member of the Inland Boatmen's Union, the IBU, and worked his way up through the career on deck, line handling and doing ship assist work, primarily in Los Angeles, San Pedro Harbor area, Long Beach, LA, but a tugboat deckhand.
Tell our audience what happened. Why did this case happen at all? What happened to Rick?
Well, Rick was hurt in a fairly classic overexertion situation. And what we see in the industry a lot is, you know, there's a lot of training. So these guys are trained about confined space risks, falling overboard, for example, a tug deckhand being caught in the bite of a line. These are the more dramatic, potentially life-threatening situations they face. But what we see so often is that these crew members suffer these overexertion, lifting injuries. There's a certain machismo in the industry, and Rick was working at Foss is a safety-conscious company, but they lost the main winch on this tugboat one evening, and they had to get that boat fixed. And they went into port, and this young captain, great guy, but he wasn't trained properly on lifting safety, pushing and pulling. And they decided basically to use brute force to fix this piece of equipment.
Right. Well, when a worker who's got the experience like Rick has, right, says, you know, this is way beyond what we're supposed to do, what do the captains say?
Well, the thing is, what happened here, and is so common, is that these guys don't know that it's well beyond what they're supposed to do.
You're talking about the workers.
I'm talking about the workers. And so if a captain says, hey, we got to get this boat back online, and if that means pick up a 100-pound or 150-pound object, these men can do this, and they will do that to keep that boat going. And what they don't understand, and here the captain did not understand, that the things that he was having these crew members do, he didn't even realize was very unsafe and ultimately resulted in a serious injury to this deckhand.
To Rick. Yeah.
Exactly.
So he couldn't work. He filed a claim.
Yeah. So he didn't file a claim. He couldn't work. Yeah. He simply went to the company and said, I'm really hurting. I need medical help. Yeah. And the company went into the mode that so often these employers do, which is not how did this happen? How can we help this guy? But how can we prove this wasn't our fault? How can we blame this on Rick? And they told him right away, hey, this is just, you're just worn out. You know, this is really not our responsibility. Yeah. They paid him his meager maintenance and cure. They did take care of his medicals, but they went in full mode right away to say, we're not responsible. So when Rick came to us, we interviewed him and we found out about the circumstances of his injury.
Yeah. And this was a permanent disabling injury.
This was, well, you know, he didn't know that at the time, but yes, it was. His injuries were
He couldn't work anymore.
He was done. He couldn't work, yeah. And he was at risk of losing his home, his house that he had worked so many years to pay for, and really would have been homeless if we hadn't come to his aid.
Yeah, so this show is all about, there are seamen that are injured, and when they go to their company, and this happens a lot, as you mentioned, you know, the company says, your fault, it's no big deal, whatever. How did Rick come to you? How did he decide that I need to sue these people to get compensation for what happened to me?
He actually came to us because he'd come to us a few years earlier. He had suffered a shoulder injury. And I talked to him and I said, you know, what do you want? And he said, I want to get back to work. That's all I want to do. Yeah. And I said, that's great. So what we're going to do is you go and tell the company you're entitled to care, medical care. And he got better. He went back to work. And he was very impressed by the fact that we didn't say, oh, make a claim, you know, say you're hurt. We said, go back to work. That's what you should do. And so when he got hurt again, he thought, this time I'm really in a bad way. Yeah. He called me personally and said, you know, Ed, I need help. I'm in trouble here and they're not taking care of me.
So what were some of the legal challenges you had in pursuing this lawsuit?
Well, we face serious challenges in these cases because the law is set up in a way to protect these seafarers.
You're talking about the company.
The law is designed to protect the seaman itself, the worker. Okay. The companies, it's so common that once somebody gets hurt, they're the enemy. And so we have to go in and we have to prove our case. These are not easy cases to win, notwithstanding favorable law. So we have to go in right away, and we need to get their records. We need to get the fellow crew members deposed or under subpoena to prove the case here. And in a case where there's no dramatic accident, I mean, if a piece of equipment fails, a winch breaks and a boom falls on a guy, that's an easy case. This is a case where, you know, they had the ammunition to get away with what they were trying to do potentially, which is to say, oh, this guy's just worn out. He's just, it's his fault for not doing the right thing. Right. And the way we prove that is we get the records from them, we get on their boats, we get into their crew, and we can prove our case, and we bring in the experts to show that what happened here was not some guy just being worn out, but some guy doing something very dangerous and something that this company should have known was dangerous and should have trained. That captain should have known how to do this and not injure his crew members.
And later on in the show, we're going to have that expert, Ira Janowitz.
Ira Janowitz,
yeah. Who's an ergonomics expert, is that
He's
correct?
an ergonomics. He's an ergonomist, yes.
And actually, the testimony and the evidence that he provided was very convincing to a jury, wasn't it?
It was very convincing. This is not something that lawyers make up. This is hard science, and responsible companies, and we see this a lot more our shore side. We see this. Ira, for example, worked for Muni in San Francisco, making sure their cable car operations were safe. He is an expert on workplace safety. And when we talked to him about this, we looked at it and thought, well, this seems really over the top, extreme what they were doing. And he looked at it right away, and he spotted things that we wouldn't have identified. So we brought him in. We got him out on that tugboat. Yeah. And for example, when he looked at the fact that the elevated deck above that winch had Mr. Amavisca, had Rick leaning over on this job and pulling, he might as well have been leaning over, lifting up an anvil. Yeah. And he was able to do the science and work modeling to prove up how that violated workplace safety and known ergonomic models.
Right, and you were, between you were the principal trial lawyer in this case, yes?
I was the principal trial lawyer on this case, although in our firm, we have two partners on every single case, so that it's like a pilot and a co-pilot. And sometimes I may be the pilot, but it may be that Kurt has to step in and take over. This case, Kurt and I worked it up together. Ultimately, I tried the case.
Although there was an interesting aspect of the case. Oftentimes what we do when a case is going to trial is we have the other partner take over any settlement discussions that are going on with the other side. And we do that to relieve the trial attorney of that distraction, because settlement discussions can oftentimes be very distracting.
Emotionally distracting?
Well, just in terms of organizing your time, and if you start to feel like a settlement is imminent, it's, you're not keeping the pedal to the metal and going and working as hard as you need to. So we do that. We put up kind of a little bit of a Chinese wall between the attorney that's handling the settlement negotiations and the trial attorney, so the trial attorney can maintain his focus on preparing the case.
Right. And the final result was?
Well, we ended up getting about 250% of what their highest offer ever was in the case.
It was settled confidentially.
Right. It was settled pursuant to a confidentiality agreement that they had insisted on.
Well, we have with us today your client, Rick. So let's bring him on for a minute and meet him, okay? It's my great pleasure to introduce Rick Amavisca to the show. Welcome to the show, Rick.
Thank you.
Take our audience back to the day you were injured. What did the captain tell you to do?
The winch was busted, and they wanted to move an arm to fix it. So the engineer went up on the dock and got a crowbar, and we were trying to line it up to take off the ram.
Was there a point in time when you realized no human being can do what he's asking us to do?
Well, we kept on trying. In the business, you try to fix it. We had a job after that, so we're trying to hurry and get it done. So we went through a few scenarios on how to try to get it to work.
Was the captain supervising you at
Yes,
the time?
he was right with us. Yes.
He was there?
Yes.
But did there come a point in time when you realized, hey, I can't do this?
Yeah, we all kind of came to the same conclusion.
But by that time, you were hurt.
I didn't know it at the time.
Yeah. When did you find out you were hurt?
It wasn't until I was driving home that night.
What happened?
I drove home when I was getting uncomfortable.
Yeah.
And I live about an hour, 75 miles away, so it's an hour and some change, 10 minutes.
Yeah.
Got off at home about 3 in the morning, and I went to climb out of the truck, and my knees were hurting, my back was killing me, and I thought, well, no big deal. I'll go lay down. I'll be fine in the morning, because I'll be back by 2 in the afternoon. Mm-hmm. And I couldn't sleep, so about 8:30 in the morning, called my supervisor, told him, I don't know what's going on. I have no idea, but my back's killing me, my knees are killing me right now. And he goes, what do you want to do? Do you want to take a day off? I went, sure. And it happened to be the last day of our shift. So he goes, why don't you do this? Take the last day off. Give me a call on Friday and see how you're doing. And we left it at that. Called him on Friday, told him, I'm doing better, but I haven't done anything. He goes, you want to give it a shot on Monday? I told him, sure. Got into work that Monday afternoon. Yeah. He asked me how I was doing. He happened to be coming out of the office at the time. And I told him I felt better, but, you know, won't know until I work. So he goes, okay, give it a shot. See what you can do. Let me know if anything goes wrong. Okay, worked that night, got off, went home, same thing happened again. Called him in the morning, told him, hey, something's wrong. I think I need to see a doctor.
And when the doctor said what?
The first one, he asked me what doctor I want to go to.
Yeah.
And I told him I really didn't care.
Yeah.
And I went to one in Oceanside that they approved. And the doctor said that I might have had a strained back. And he wanted to put me on physical therapy. So I went through physical therapy.
So you're out of work now for how long?
And I don't remember the exact frame of time, but it was probably about a month after the accident that I was kind of going through that process.
Okay. Was the company covering you at that time? Now, Ed mentioned that you, as a maritime worker, you worked for the same company for 30 years, is that right?
Yeah, ended up 35 years.
It was like a family.
Yes, I started when I was a kid.
Yeah, so
early 20s.
You would be kind of reluctant to sue your own family members, right?
Yes,
That's
exactly.
something you didn't want to do, right?
No.
But unfortunately, they took a hardline position, and they didn't want to help you out. They didn't want to own up. They didn't want to own up to their responsibilities, right?
Didn't seem it to me.
To every maritime worker that's watching this show, what do you say to them about what you have to do sometimes to make sure that you're taken care of?
It's another world. You've got a lot of the workers that think they're maritime lawyers down there, but it's a world you don't understand, and you need someone to give you good advice to get you through it, because the company will take you on another road.
Well, actually, you got a settlement right after the verdict, but it came out very much in your favor, which we're glad to see.
Oh, he did a great job.
Well, I want to thank you very much for being on the show, and we wish you well in your retirement. You're retired now, right?
Yes, sir.
Okay, thank you.
Thank you.
We have with us your expert, Ira Janowitz, so let's bring him on right now. It's my great pleasure to introduce Ira Janowitz. Welcome to the show, Ira.
Thank you.
You are the man, aren't you?
Yeah, well,
you're the leading expert, aren't you?
I am an expert in ergonomics, and I've done a number of cases in maritime field for these attorneys and others.
One of the reasons we wanted to have you on the show is I think Kurt can best explain how influential the evidence that you provided to be able to prove their client's case. What was that?
Well, in the Amavisca case, as in a number of our other cases where we've retained Mr. Janowitz, we're constantly met with the argument by the defense counsel that, you know, these gentlemen are seamen. They should be able to pick up hundreds of pounds or move hundreds of pounds or pull or push. And they try to belittle our theories of liability that are based upon overexertion injuries.
In other words, the worker did it to himself.
Right. They always are managed to blame the worker, even though he's following orders and he's picking up a 150-pound block or you know, manipulating some huge weight. And so we turned to the science of ergonomics, and were able years ago to locate and identify Ira, who's a professional ergonomics expert. He's worked for various companies, Wells Fargo and lots of big Clorox company, and has studied workplace safety on shore. And we were able to take his expertise and apply it in the maritime setting. And it's just extremely helpful in these cases. It's necessary, really, to have an ergonomics expert who can come in and explain why it is that it's negligent for the employer to have a work procedure or a process where an individual seaman is being ordered or directed to lift, push, or pull excessive weights that are way beyond the safe lifting, pulling, pushing limits that are identified in the various materials.
I know you created a lot of diagrams and software programs that help prove their case, but in simple terms, how were you able to show what happened to Rick was the company's fault and not his?
Right. Well, a lot of ergonomics is basically trying to find out how much is too much, whether it's lifting, pushing, or pulling. In his case, he was doing very forceful pushing and pulling, and there was no way to go back and measure exactly how much the force was. So we had to use various ways to estimate what the force was, and then use this in formulas to try to figure out how much is too much, and was this in excess of what's accepted.
Right. So it's just a matter of convincing a jury that this was too hard a job for anybody to do, right?
Well, that's a large part of it. I mean, it's kind of like if you go back in time, the garbage collectors. There was a time when the garbage collectors on our city streets would pick up the garbage cans and dump them in. Well, they don't do that anymore because ergonomic science taught them that it was just too heavy to do that on a repetitive basis. And the more that the ergonomics experts study these overexertion injuries, the more they're finding out that even weights that we sometimes in our daily life will pick up and manipulate, it's still dangerous to do that. You know, picking up 60, 70, 80 pounds and doing it in a somewhat awkward position can be very dangerous. Now, it doesn't mean you're going to get injured every time you do it, but it is a risk of injury that's not acceptable in a maritime workplace.
Ira, you handle cases not only in the maritime industry, but a lot of different industries where you're looking at work exertion and that sort of thing. What do you say to all the workers out there to help them or advise them about maybe reevaluating some of the stuff that they're made to do by their employer?
Well, one thing they can do is look at the training. And in this case, for instance, there was no training that addressed this kind of task.
Really?
And the general message for the training, according to Rick, was basically, don't strain yourself, but get the job done. And that's way too vague to be useful. Other aspects of the training told people that when they lift, they should take 20 deep breaths and warm up, do jumping jacks or things like that before they lifted. And, you know, when you're lifting something very heavy, especially in an awkward posture, that's not going to cut it. So the training often is a smokescreen that, and I'm talking now specifically about the maritime industry, the training is a smokescreen that doesn't really protect anybody.
Well, thank God, you know, you are the expert that you are, and we really appreciate you, showing us exactly what happened and how to prevent these kinds of injuries. And we thank you for being on the show. Thank you.
Thank you.
Let me ask you guys some questions about the Jones Act, because what is the Jones Act? Who does it apply to, Kurt?
Well, the Jones Act's a federal statute that was passed in 1920. And it's a complicated statute because it involves shipping and where hulls are built and whatnot. It was designed originally to protect American shipping. But one of the key provisions, one of the provisions that we use all the time in our practice, relates to personal injuries. And what the Jones Act says is that any seaman who is injured at work is allowed to bring an action either in the federal court or in the state court to hold the ship owner liable the ship owner employer liable for his or her injury.
It's kind of like workers' compensation, right, Ed?
It is, very much so.
But in this particular industry, the maritime industry, they have their own set of rules and regulations, like the railroad industry has their own set of rules and regulations under FILA, right?
Exactly. In fact, the Jones Act incorporated FILA when it was passed, and incorporated all of the law that existed for railroad workers. Seamen do not have the right to workers' compensation.
Right, because they have their own statutes.
They have their own statutes, but they are required to file a lawsuit. If the employer does not agree to take care of them, They don't have a user-friendly remedy. They're required to go into state or federal court and file a lawsuit to get the compensation that any land-based worker would automatically get without proving fault. So you have to prove negligence. And the Jones Act also works in tandem with, we call it the seaman's remedial trident, like Neptune's trident. There's a right to a warranty of seaworthiness for their workplace and their equipment, and also a right to maintenance and cure. So they have those three remedies, all of which have to be brought in a civil lawsuit.
And let's explain what he just spoke about, cure, maintenance. What does that mean?
Well, as Ed was saying, there's three traditional remedies that seamen have. The first one's called maintenance and cure. And what that requires is that the vessel owner provide a stipend for the seaman while he or she is injured.
That their regular pay, or is it a little bit less?
No, it's less than that. The idea is it's an amount
kind of like a disability payment.
It's an amount necessary to live on shore while they're treating and receiving medical care. Sometimes it's specified in the union contracts as to what the maintenance rate is. Sometimes we fight about it with the ship owner. Sometimes they pay a small amount and we argue that it should be more than that. So that's the first remedy, is maintenance and cure, and that's owed by the employer ship owner without regard to fault. It doesn't matter if the ship owner was at fault or not. It doesn't even matter if the accident or illness that developed was on shore or even related to being on the vessel. We've had maintenance and cure cases where somebody develops an illness while they're in the service of the vessel, but not even aboard the vessel at the time. So that's the first remedy. The second remedy Ed touched upon, which is the breach of the warranty of seaworthiness, which is a warranty under the general maritime law that is implied in the law that every ship owner owes to every seaman aboard the vessel to ensure that the vessel and all of its equipment, its work procedures, policies, and other things are reasonably fit for their intended purpose.
It's like if you went out in a boat with a hole in it, that's not seaworthy, right?
Right, but that's kind of the traditional one. I mean, we deal with work methods that aren't seaworthy very frequently in our cases. So it applies not only to pieces of equipment, but to methodologies of work aboard the vessel.
And then the third thing?
And then the third is the Jones Act, which is where you have to show negligence on the part of the ship owner, and you have to prove fault, and you have to show that the negligence or the fault was the cause, the legal cause of your client's injury.
Right. Last question, and you can both answer this. You have a lot of people contact you, about cases. How do you choose the cases you choose to represent?
Well, it's hard to say. We look at lots of different factors. There typically has to be enough money at stake in cases to make it worth the plaintiff's while to hire an attorney. So we look at how bad was the injury, what is the age of the plaintiff, is there clear fault on the part of the vessel owner in causing the accident, and we also look at more kind of intangible things. Is the employee a good employee? How long has he worked for that particular company? Is he somebody that's had 10 lawsuits in the past, or has he never had a lawsuit before? So there's all kinds of factors that go into it. But we find that most of the seamen who contact us with serious injuries are cases that we are interested in and usually can help them in some way.
Yeah, well, we thank you both for being on the show and doing a good job. And congratulations again on the case. Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.